Hi, everyone. Thank you very much for joining our Fireside chat today. My name is Lydia Tan, and I am a quantum and accounting expert at BRG in Hong Kong and a committee member at Hong Kong 45. For those who are new to Hong Kong 45, we are a Hong Kong IAC young practitioner group. We regularly organize seminars, career events, and social events, and our aims are to promote a platform for members to learn from each other and leading professionals. We welcome members from all age, and our membership is free. And so we hope more of you will be signing up on our mailing list and follow us on LinkedIn. The Fireside Chat series is one of our flagship initiatives to hear from the leading practitioners in the arbitration practice, their life experience and their career journey. Today, we are honored to have Jern-Fei QC with us. Jern-Fei is an experienced counsel specializing in commercial litigation and arbitration, with extensive experience appearing before courts and tribunals and sitting as arbitrator in different jurisdictions, including Hong Kong, Singapore, Malaysia, England, BVI, Cayman Islands, and Luxembourg. He has acted as counsel in more than 350 cases and as arbitrator in more than 30 cases. Jern-Fei is frequently described in the legal directories as an absolute superstar of the bar, one of the biggest names for Asia-related arbitration, and an absolutely brilliant advocate. He is recommended by the Legal 500 APAC as a leading practitioner in a number of areas: commercial, shipping and commodities, construction, energy and infrastructure. And he is recommended by the Chambers Asia as a leading practitioner in international arbitration. I am also pleased to introduce the host of today's interview, Sylvia T. Sylvia is one of the committee members of Hong Kong 45 and a counsel in the dispute resolution practice and ASHRS in Hong Kong. Sylvia is a commercial arbitration and litigation practitioner who has acted in cases involving a variety of industries and with a focus on multi-jurisdictional proceedings in the financial services, infrastructure, and resources sectors. Before I pass to Sylvia for the interview, just a few housekeeping points. There is a Q&A function, so please feel free to share your questions. And I will also mention that this section is also recorded and will be uploaded to the recordings of the Hong Kong 45 website afterwards. So please feel free to share with others. And on that note, I will hand over to Sylvia.
Thank you, Lydia, for the introduction, and thank you, Jern-Fei, for accepting our invitation to attend this fireside chat. I'll just jump in from the start, inspired by, as I mentioned to you, the Inside the Actor Studio style interview. I'll start from the very beginning. So you grew up in Malaysia. Whereabouts in Malaysia?
Well, firstly, thank you so much, Sylvia, Lydia, and the entire HK45 for the invitation to speak to you all this afternoon. It is obviously a real privilege and honor to be able to speak to you and to share with you my insights and experiences in our sector. To your question, Sylvia, I grew up in a town called, well, now a city called Petaling Jaya, which is adjacent to Kuala Lumpur in Malaysia. I was born in PJ, as it is commonly known, and I grew up there. I did my primary and most of my secondary education in PJ in Malaysia, and going on to the UK only in 1997 to do my A-levels.
And when you were growing up as a child in Malaysia, did you ever dream about being a lawyer? Were there any early childhood influences that you think led you down this path?
I think the easy and honest answer to your question is no. I never dreamt of being a lawyer, never even crossed my mind of being a lawyer. I think when I was younger, I might have flirted with the idea of perhaps being an airline pilot. Not so ambitious as to become an astronaut. I was hoping to do something perhaps in business as I grew a bit older. and still, never contemplated the idea of being a lawyer. However, I do recall that when I was younger, I did say to my family one day that having watched a TV drama series on the law, that I thought being a judge sounds and looks like pretty good fun. And that's what I want to do when I grow up, only to be told that there wasn't an easy and direct path to being a judge without first being a lawyer. And I thought to myself, oh, in that case, maybe I will think about studying law. But that was when I was much younger. And the truth is, I didn't really make up my mind to study law and to become a lawyer, I think, until possibly shortly before I embarked on my A-levels in the UK. And I really had to give some thought as to what I was going to study in university. I couldn't think of anything else I was particularly interested in. And so I decided to choose law. But even then, I was not sold on the idea of being a lawyer after I graduated.
That actually made me chuckle, because I often joke that the reason I became a lawyer is because I watched too much Yak Ho Huang Teng when I was a kid. Nice to hear someone of your stature share a similar story. So tell me a little bit more about your move to the UK then. How did it come about, and what then eventually cemented your choice of career?
Well, as with a sizable proportion of youngsters, as we then were, of my generation, a number of us, after having completed our fifth form education in Malaysia, would choose to further our education at either private institutions of higher learning abroad or back home in Malaysia. I chose to go to the UK to further my education. And because at the time, rightly or wrongly, we had assumed, my family and I had assumed, that I would stand better prospects of securing a place at university in the UK, at least at a university and hopefully a course of my choice in the UK, if I had first undertaken A-levels in the UK. Plus, it would also make for an easier transition to life at university in the UK if I had perhaps spent a year and a half in the UK, getting accustomed to and adjusting to life outside of Malaysia. So with that in mind, I decided to head off to UK to do my A-levels. I completed my A-levels in a year and a half, as was customary back then. And then I was fortunate enough to have been accepted to the University of Cambridge to do a BA honours degree in law, which I did for 3 years. And then even when I finished, Sylvia, I wasn't necessarily sure that I was going to be a lawyer. This was before the financial crisis obviously had beset the world. And a lot of my peers, including those who studied law at university at that point in time, were pursuing careers in finance, in banking, as management consultants. And that was something which, again, I was thinking long and hard about. But I really enjoyed the intellectual challenge of studying law, of analyzing problems and applying the principles which I had studied to problems which, whether hypothetical or real, which I had encountered. And I thought, you know what, this sounds like a pretty fun way to build a career and to pursue a living. And I thought to myself, it is perhaps something that I should be thinking of. And so I ultimately decided I would become a lawyer. But even then, I never thought that I would stay on in the UK to pursue a career as a lawyer. Instead, I had, for a very long time, even up until the point when I did my, what was then called the bar vocational course. So after you graduate, you do a year at bar school. I thought even at that point in time, I was likely to return to Malaysia to practice as a lawyer rather than staying on in England.
So what was it then that, sort of cemented your decision to stay on in England and practice as a lawyer? Was it, and maybe allied to that, was that when you had your first exposure to arbitration? Maybe tell us a bit more about that.
Yes, I remember vividly. It was around 2001, I think it was, which was the year in which I did the BVC, the Bar Vocational course at City University in London, or what used to be called the Inns of Court School of Law, which was then part of City University. And it was a time in which I was getting ready, obviously, to return. So I thought to Malaysia to practice law after I finished my BVC. A lot of my peers, particularly those who are English, had embarked on the BVC year, having already applied for and armed with pupillage offers from sets of barristers' chambers in London. I didn't apply for pupillage before starting the BVC, as was traditional back then, because you would apply, hopefully you'd secure an offer whilst you're doing the BVC, and then once you finish your bar course, you will then start pupillage at a set of chambers in London. I didn't do any of that. And the reason why I didn't do any of that was because I, in my wildest dreams, never thought I would ever be good enough to qualify for pupillage at the English bar. And therefore, the thought never crossed my mind to apply for pupillage. And which is why my plan all along was just to do the bar course in London, which would then exempt me from the Certificate in Legal Practice, the CLP in Malaysia. Then, upon my return to Malaysia, I could then commence chambering or pupillage in Malaysia. So that was the point for me doing the bar course. It wasn't until during the bar course, I started realizing that a lot of my peers, people that I had gone to university with, had succeeded in securing pupillage offers, some from very, leading sets in London. And I thought to myself, well, I went to university with these people, and I don't think that I am less of a lawyer than they are, or that my legal skills are not anywhere near as good as theirs. In fact, quite to the contrary, I thought that I would be able to hold my own with them, and perhaps even exceed the standards that have been set for them by sets of chambers who have interviewed them and offered them pupillage. But the problem for me at that point in time, and you must remember this was back in the 2001, so the turn of the millennium, without wanting to sound too dramatic. And back then, the bar, the English bar, was a very different place from what it is now. There were next to no one at the English bar, and certainly not at leading sets of chambers in London, with my sort of background. There was nobody, or there were very few, very, very few, handful of people who looked like me, who sounded like me, and to the extent that there were those who, what I would describe as barristers or pupil barristers from non-traditional backgrounds. Almost all of them had grown up in England. I didn't grow up in England. I didn't attend a famous school in England.
Well, until university.
Well, I had that going for me. That's true. I wasn't entirely handicapped in that regard. But then again, there were a lot of people who graduated from Oxbridge and other famous universities in England as well. But to me, one of the biggest hurdles was that I didn't look the part, and I didn't fit the traditional idea of a barrister. As Marian Wright Edelman from the US once famously said, "You can't be what you can't see." And I couldn't see me at the bar because there wasn't anyone like me at the English bar. And notwithstanding that at that point in time, there was already talk of diversity in the legal profession, and people were, it was said, committed to the idea of diversity. I remember being struck by a piece of advice that someone, I think in an effort to be helpful, and perhaps in an effort to encourage me to be practical and realistic, said to me, says, talk is cheap, Jern-Fei. Just look around the panels of barristers at some of these leading London sets. How many names on that panel do you recognize as, having backgrounds which are similar to yours? So, it's one thing to say, these sets are all for diversity. It's quite another, obviously, in terms of who they recruit, who they make offers of pupillage to and offers of tenancy to. So that really struck a chord with me. I came very, very close to not applying for pupillage, but perhaps I am quite a stubborn person, not one to give up. I decided I would apply. After all, what is the worst that could happen? The biggest opportunity cost is one of time. I would just end up frittering perhaps my time pursuing a hopeless application. But I was pleasantly surprised to receive invitations to interview and also several pupillage offers thereafter. And I took one of those pupillage offers, and even then I was convinced I wouldn't be offered a permanent place, what we call a tenancy, at the end of my pupillage year, and was also pleasantly surprised when that materialized. So that was my path to practice as a lawyer, or more particularly as a barrister in England. So I guess, Silver, I would describe myself as an accidental barrister in that regard. And footnote, I hadn't yet been exposed to arbitration at that point in time.
Right. So do you then remember your first case as a counsel and your first arbitration as a counsel?
Yes, I do remember. My first case as counsel, let's talk about that first, was I'd like to talk my first two cases as counsel, because the first case as counsel I did was in the winding up court. So it wasn't very exciting, where you turn up, it's a sea of bewigged barristers. There are about maybe 50 in the winding up court. And what you do is, when your case is called, you stand up in the company of these 50 bewigged barristers, and you ask for the usual order. I have no idea what the usual order was. I still have no idea what the usual order is. I don't really do much insolvency, but at that point in time, the clerks thought that it was a good idea for me to get some advocacy experience on my feet, even if it just meant me standing up and asking for the usual order, which I did. I remember being struck with the nervous prospects of being asked by the judge as to what kind of usual order I would be seeking. Thankfully, no such question was posed to me, although it was posed to the barrister who appeared before me, because there was a problem with his petition. And no such thing happened to me. So I remember that was my first piece of advocacy, although it wasn't what I would describe as advocacy, because I simply asked for the usual order. Far more memorable was the second outing I had as counsel. It was in the county court, still no arbitration. It was at the county court. I was representing a credit card company who was seeking to recover a debt. And I was sent off to some county court in southeast England. I can't remember where the county court is now, but I remember it was before a judge, and the defendant who appeared on the other side was a litigant in person. And it so happened that she was a single mother on benefits who was unable to pay her credit card debt, which I was seeking to recover on behalf of my client, because she had been, she says, unlawfully dismissed by her employer, which happened to be the very same credit card company who I was representing, who was seeking to recover a debt. So I turned up and I thought, wow, this is a terrible gig. I look like I am, obviously victimizing this poor woman. And so I thought, what, I will try and emote. I will express to the judge, obviously, my sympathies for the defendant. So I started by saying to the judge, I said, I obviously am very sympathetic for the plight that the defendant finds herself in, but a debt is a debt, and it has to be repaid. To which, much to my shock and horror, the judge said to me, Mr. Ng. And the thing is, as I've since discovered in England, and of course this was again some 20 years ago, when a judge in England is able to pronounce my last name, Ng, correctly, either it means that I'm due for high praise or I'm due for a real rollicking. Unfortunately, it turns out on this occasion, he had reserved it for the latter, because he said to me, he says, Mr. Ng, any tears that you and your client shed for the defendant are crocodile tears. And I had my breath taken away. Oh my goodness, it's just my second outing as counsel. This is not going well. And then he continued. The judge says, you are just here for a pound of her flesh, aren't you? Says the judge. And I just thought to myself, at that point in time, being argumentative and stubborn, as I mentioned before, My instinctive response was to say to him, yes, and what's your point precisely? But I thought the better of it. I thought, oh, you know, that's not very good advocacy. Know your audience. So I decided to try and defang the situation and focus on the law instead. I ended up getting what I wanted at the end of the day, but not without being put through my paces by the judge. And it was a terrific lesson in advocacy, how to deal with irascible judges and sometimes irascible arbitrators. But it also taught me the importance of being flexible, being nimble, and being able to react to perhaps unforeseen situations, whether it's in the course of a hearing or in the course of anything else that you're doing for that matter.
Great. So your first first arbitration as a counsel then, do you remember
Yes,
that?
I do. This was, in fact, an expedited arbitration, which I did in Singapore. It was an SIAC arbitration, and we had to complete the arbitration, I recall, before the end of the 6-month period that was set under the SIAC rules, which, as it happened, coincided with the week just before Christmas. So I recall it was again a real invaluable lesson in how efficient advocacy, how advocacy can be efficiently deployed within the constraints of time. It was also a real life lesson in how efficient arbitration could be in general, because there was real urgency with us completing this arbitration within that 6-month period, and we just got stuck in. We had days of hearing where, I recall particularly, there was one day in particular where I had to cross-examine, apart from the usual short breaks, shorthand writers adjournment. Otherwise, I was on my feet figuratively, cross-examining for some 12 hours. I remember there's one day in particular, and we started, in fact, at midday, and we finished at 10 p.m. And we went on for 5 days. And it was a very memorable experience, and I thoroughly enjoyed myself. It was also the first time that I had acted as lead counsel in an arbitration with a speaking role, and the fact that I was able to cross-examine, I think, something like 4 or 5 witnesses on the trot was certainly something I will never forget.
That's an amazing first case as first arbitration case. What about your first arbitration as an arbitrator?
Yes, I was very fortunate to have been given my first break by the LCIA, the London Court of International Arbitration. And I was selected by the LCIA court I think it was possibly 10 years ago now, give or take. In my very first case, in fact, I didn't even know that the LCIA knew of my existence, let alone my ability or my availability to act as an arbitrator. It was a case that was a little less exciting than my first case as counsel in an arbitration, because it was a case that was not defended. In other words, the respondents were unrepresented. But it was a very, very fun case because it was a tribunal of 3. And I learned a lot from the presiding arbitrator on the panel, who is Klaus Reichert, who taught me a lot about the ropes, about being an arbitrator. So he was very patient. He explained to me, the thinking. And of course, what was challenging about the case was only the claimant was represented and the respondent was not. But even then, we went through the whole process of ventilating the issues in the case to ensure that the unrepresented, not participating respondent's point of view was carefully examined. So that was my first break as arbitrator. I'm pleased to say that since then I have received many more appointments, almost all of which involve respondents who do participate in the arbitration and are far more exciting. But certainly that first break was a very useful introduction to life as an arbitrator. And I'm very grateful that there were more senior, seasoned arbitrators who were more than willing and able to step in to show me the ropes.
That you say it's not as exciting, but it is in its own way quite interesting as well. Would you have been notionally representing the respondents' appointed arbitrator? Is that what happened?
Oh, that's a really good question. I don't know actually. I cannot actually remember what it was, because I think it might even have been, and I don't know how this actually came about because so long ago. I think it might even have been one where the court, the LCIA court that is, appointed all three of us to the tribunal. I can't remember how it came to pass. I've obviously been in situations before since then in arbitrations where either I am appointed by the claimant and someone else is then appointed in lieu of a nomination from the respondent, just as much as I have on occasion been appointed by the appointing authority in lieu of a nomination by the respondent.
And I guess what triggered my question as well is, everyone I think on this call would be interested to know how did you go about getting your first appointment? What's the secret sauce, as they say?
Yes. Well, I'm glad you raised that question, Sylvia, because I get asked this a lot by young practitioners who approach me for advice from time to time. And my answer to them is always consistent. There is no secret sauce. Having said that, though, I do think it is important to participate in events, to obviously make yourself known to members of the arbitration community, to make yourself known, obviously, to case managers, to members of the management leadership teams of arbitration institutions, to express, obviously, your willingness with the appropriate opportunity should come along to serve as an arbitrator. And although this wasn't as prevalent back in my day when I first started out as a putative arbitrator, thankfully though, there are now more young arbitration practitioners group. There is also, in fact, I was just reading on social media that there is a very young arbitration practice, a VYAP group that is in Singapore, that's chaired by Sunita Advani, which I think is a terrific initiative, because what this does is that it gives a forum for young, and in some cases very young, arbitration practitioners to mingle, to get to know one another, to build a network, to build a community. This gives you an opportunity to meet others so that they get to know you better, maybe have a conversation with you about serious topics about arbitration, and just to get to know you personally as an individual, so that it gives them an opportunity to put you forward for an arbitration appointment when the occasion calls for it, and they will then be able to say, I have met this person, and he or she is someone I consider suitable for an appointment. But of course, the problem is that it's a chicken and egg situation at times, because the question that often comes along is has this person ever been appointed before? What is their track record like? And then the moment you say, oh no, this person has never been appointed before, there is an inherent degree of skepticism or reticence, particularly on the part of clients to testing someone out for the very first time. So to all the young practitioners out there, notwithstanding that I said there is no secret sauce, and there isn't a secret sauce, the better prospect of securing an appointment, your very first appointment, is actually through an institution. And what I would certainly encourage those of you out there who are listening and who are interested in securing your first appointment is to apply for membership of some of the what I would call the sort of younger panels. They are called different things. So for example, HK45, you have a list of arbitrators as opposed to a panel of arbitrators. The SIAC has a reserve panel of arbitrators. All of this is dedicated to younger, less experienced arbitration practitioners. Getting yourself on these panels will then give the institution the ability to nominate you for that very first appointment. And one appointment then begets another. Before you know it, you've got a critical mass of a few, and then people will be in a much better position to then promote, sell you, recommend you to their clients, to their team for appointment, because then you already have a critical mass of appointments under your belt by that stage.
That's great to hear. I noticed that we're at about the halfway mark, so just wanted to remind those listening that we do have a Q&A function. So if anyone wants to send us a question, I'll read it out for Jern-Fei, and we're happy to take questions as we go. So we've covered quite a few highs in your career, your first case, your first arbitration, and then your first arbitration as an arbitrator. I just wondered whether you could share with us what your biggest challenge has been.
My biggest challenge. I've had many challenges in the course of my career, but I think the biggest challenge I've ever had to encounter is probably some sort of 1.5 years ago, when I had to move sets of chambers in London. I've never spoken about this incident or events before, at least not publicly. And I think that was the biggest challenge for me, because within 24 hours, I had moved sets of chambers in London. But I think what made it an even more heightened challenge was, as a result of the move in chambers, I came under withering attack on social media, in the media, by certain constituencies. For example, there were legal blogs in England, and there were, opinion pieces written in the US, some of which were very critical, and there were others which subjected me to vitriol, including vitriol that had, I'm afraid to say, racial undertones to them, where some of it was just perhaps bordering on racial abuse. So I don't know if in your career, Sylvia, you have ever been racially abused, but at least I can now say I've not only had experienced indirect discrimination, I've in fact experienced racial abuse. There was a lot of association drawn between what I had done and who I am, my ethnicity, etc. And at that point in time, that was a very challenging period in my career. And however, despite all of this abuse that I was getting and the challenges that that posed, I felt that I had a duty not just to myself, but also a duty in my capacity as a role model to a lot of young arbitration practitioners, particularly in Asia, who had been following my career. The reason I say that was because when I was appointed Queen's Counsel in 2018, I was only 38 at that point in time. In fact, I'd only been in practice for some 13 or 14 years at that point in time. I had a groundswell of support from a lot of young practitioners, particularly in Asia, who wrote to me, who commented on social media saying how proud they were of me. And I was very touched by that, and how much they looked to me as a role model, as an inspiration. Coming back to the quote from Marian Wright Edelman I gave you at the start of our interview, "You can't be what you can't see." I was seen, and there were those who wanted to be what they saw in me. And I felt that I had a duty, now that I was facing a very public challenge to my career, to react in the right way. In circumstances where I came under heavy attack, including sort of racial abuse, there were two different ways I could have reacted to it. I could have gone low, which would have been the easy way to do it. And it's easy to go low, it's easy to lead by fear, and it's easy to be divisive, and it's easy to make people afraid. But that would be a very short-term view. If I can quote someone else, which is Michelle Obama, said some 6 years ago at the Democratic National Convention, "When they go low, we go high." And what I decided to do was instead to build on the positives. And I was determined more than ever before to set an example for those who are watching, including those who saw me as an inspiration, as a role model, to do the right thing. And over the course of time, I redoubled my efforts and decided to channel my energy in a positive way, to ensuring that those who come after me would not just be able to shatter the glass ceiling, but to ensure that they could stay there and weather whatever storm that comes their way. Because I had to sail into the eye of a storm, and it could have engulfed my entire career, but I decided I wouldn't give up. As I told you, I'm a stubborn person, and I'd like to think a resilient person. And since then, there were sort of four highlights in my career, which helped me channel my energy positively. The first is, there has been an initiative which I have embarked on for a very long time, that seeks to improve opportunities for those from non-traditional backgrounds who are thinking of applying for a career at the bar, giving them advice, mentoring them in terms of their application. So I channel my energy to redouble my efforts on that front. And I'm pleased to say that as a result of initiatives which I had executed, particularly in my capacity as the then head of the Foreign Lawyers Chapter of the Professional Affairs Committee at the Singapore Academy of Law, our initiative at improving access to the bar to those from similar backgrounds to mine, and those from other non-traditional backgrounds, is such that whereas 20 years ago, I couldn't see anyone with my sort of background, there are now something like 9 or 10 pupils, barristers with similar background who are now practicing at sets at the English bar. An initiative which I was fortunate enough just last week to have had recognized by the Chief Justice of Singapore in an award. This is the Singapore Academy of Law Merit Award, which was given to me at the SAL Appreciation Night and Awards Night. So I was very fortunate in that regard. Second thing which I did, which I am very proud of, is that I channeled my energy to disseminating information about arbitration, to training the next generation of advocates in terms of their skills as advocates, their their knowledge of and experience in arbitration. And so in the past year, I have taught, lectured, conducted seminars at some of the leading educational institutions in, amongst others, China. Peking University is one of those that I taught at. Renmin University School of Law is another. The East China University of Political Science and Law is yet another. The third thing that I have done, which again I'm very, very proud of, is to have acted as lead facilitator again last week at along the sidelines of Singapore Convention Week. In fact, not along sidelines, it's part and parcel of Singapore Convention Week, where at an event that was hosted and organized by the Singapore Ministry of Law, called the Reimagine, Rethink, Remake event, where we hosted a selection of some 35 young practitioners, next generation leaders, to brainstorm ideas about the future of our profession. And fourthly, last but not least, one of the most significant developments in past year has been my joining as an arbitrator member of Temple Chambers, which, as you know, is one of the leading sets of barristers' chambers in Hong Kong. I am an arbitrator member, so I'm not a barrister at Temple Chambers, but in my capacity as arbitrator member, I have been very fortunate to have been able to contribute to the legal ecosystem that is Hong Kong. So these are the ways in which I reacted to what was arguably the biggest challenge in my professional career.
Thanks so much for sharing that. I mean, it's I am sorry to hear about what you have had to go through. I would say on a personal note that I do identify a lot with some of the challenges that you've mentioned, although I have come nothing close to experiencing what you've had to experience. So thank you so much again for sharing this very personal challenge to you and giving us some truly helpful tips on how best to respond to adversity and providing some inspiration for those on the line. I think this also highlights the importance really of regional diversity. And I think that's a topic that has come up very frequently in recent years. And you've mentioned some of the initiatives that you've been part of that help address this issue. Is there anything that you would propose that, for instance, the institutions like the HKIAC, who's organizing this this chat and on the line, is there anything more that you think can be done?
Yes, I think there's lots more that can be done, Sylvia. And, I have been very fortunate to have had a lot of great opportunities presented to me over the course of my career. But I think more can be done because there are lots of terrific practitioners out there, young practitioners included, who perhaps because they are not given the airtime, the space, the platform, haven't had the same opportunities presented to themselves. The institutions can play a very important role in this. Don't get me wrong, I think diversity in all its forms is very important. But VK Raja, who is the former Attorney General of Singapore and a former Court of Appeal judge in Singapore, delivered a very thought-provoking, it wasn't an address, in fact it was GAR Live, much like the fireside chat we're having at the moment at GAR Live Singapore a fortnight ago, where VK emphasized the importance of regional diversity, which I think it is important. Many, if not all of you who have dialed in for the session this afternoon, I've recognized some, I recognize a lot of familiar names from the region. We obviously are specialists, we are exponents, we are members of this regional arbitration community. There is a lot that is distinctive about the work that we do, that is unique to the region in which we operate. But there are so many of us who could do with opportunities to excel either as counsel or as arbitrator. What I think the institutions can do, and in fact are already doing, and I'd just like to single out in particular, not just the HKIAC and the SIAC, which I've also mentioned earlier on in our conversation, but there are other arbitration institutions who have been really excellent in showcasing regional talent in their events, in the course of activities which they organize. And the Shenzhen Court of International Arbitration, with whom I have got an excellent working relationship, I've been involved in a number of the initiatives over the years, is really excellent in showcasing regional talent, as is many of the other arbitration institutions in mainland China. I have spoken at also at the Hainan International Arbitration Court events. There is, of course, the Shanghai International Arbitration Center, which again is truly terrific. But just to give you an example of the brilliant work that, amongst others, the SCIA does, the Shen Guozhong does, is every year they organize a mooting competition, which is the FDI Moot Shenzhen, which serves as the China national rounds for the global FDI mooting competition, where this is a perfect opportunity for the next generation of arbitration practitioners in China to showcase their talents, to interact with domestic as well as international arbitrators and arbitration practitioners. And alongside the competition itself, the SCIA organizes a series of educational events, webinars, seminars, workshops, etc., where they invite distinguished, experienced panelists to speak at these events, extremely well attended. And as a level of interest in the breadth of regional talents that we have got on offer, both in terms of students as well as speakers, I was struck by the fact that the closing ceremony of the FDI Moot Shenzhen, which, by the way, whose national sponsor is Jin Zheng Tongda and Neil, which is again another leader in this field, and to which I was very honored to have been invited to speak at the closing ceremony of the final of the FDI Moot Shenzhen 2022 competition, alongside, amongst others, the president of the SCIA and the Hong Kong Secretary for Justice, Paul Lam, recently was attended, or sorry, not attended because it was virtual, was viewed by some 14,000 viewers. I mean, that is a phenomenal number. But, this is precisely the sort of events, big events of that kind, smaller scale events of the kind that we are on at the moment serves as a conduit to showcase regional talent. That is a good way, to my mind, at least amongst the younger generation, of promoting regional diversity. The other way I think of promoting regional diversity is to promote and encourage diversity in the teams that you're working in the arbitrators that you select. One of the things I'm very proud of is that in a lot of the teams, council teams I work with, I've had the privilege of working with and mentoring some truly exceptional young talent regionally. There are too many to name, but I just want to single out a few, some of whom I know are watching, so without wanting to embarrass them, none of them know that I'm going to mention them. You know, some of the really great people that I've had the privilege of working with over the years are Alan Lee from Jin Zheng Tongda and Neil, Nathaniel Lai from Sidley Austin, Jackie Fung from Kirkland and Ellis, Constance Zhao from Kingwood and Mallisons, Jacqueline Law from DeVoe Chambers. You know, I've got so many excellent juniors at Temple Chambers, Harrison Miao, for example, John Chan, Queenie Lau, Natalie So. So, you know, these are, you know, examples of the ways in which institutions can promote regional diversity amongst the young, and especially in terms of a micro level, the ways in which those of us who are already established practitioners can also encourage and cultivate regional talent, particularly amongst the younger practitioners.
That's great. We've got a question that has come in, but and I'll certainly want to address that as well. But one thing that your comment about the 14,000 participants has triggered is, you know, another hot topic in recent years is about how the center of gravity for arbitration has seemingly shifted east. Is this something that you would agree with? Is this something that you might arguably say is reflected in your career as well?
Yes, yes, and yes. Absolutely, 100%. In fact, to those of you who read my LinkedIn posts from time to time, so thank you very much. You know, always good to know that there are those out there who are interested in what I have to say on social media. Will know that one of the phrases which I commonly hew to in the course of my posts is the fact that we are now living in what is best termed as the Asian century. You know, the world has changed, people have changed, you know, relationships between countries have changed. But certainly one thing that I have seen manifest itself in terms of our sector, the dispute resolution sector, in particular the international commercial dispute resolution sector, is the fact that I do see the epicenter of disputes has moved gradually eastwards and shifted towards Asia, or certainly over the course of the past 20 years. In a sense, it tracks obviously the evolution of the global economy, which again, the epicenter of which has also tacked eastwards towards Asia. You have the economic powerhouses of China, India, Indonesia, amongst others, obviously propelling this change. That in turn has been reflected by the changes that we see in our sector. There are many more disputes now which are seated in Asian seats than there was, say, 20 years ago when I started. There is again a broader selection of counsel of arbitrators who come from this region, although again, back to the theme which we touched on before, I still think much more can be done in that regard. There's much more keener level of interest and awareness in Asia in arbitration. Believe it or not, who would have thought that, you know, people would be interested in arbitration in general, especially amongst non-lawyers, or at least amongst non-disputes lawyers. See to that point, you know, the point and example being the 14,000 viewers at the closing ceremony of the FDI Mood Shenzhen competition. So yes, I think it has changed. And you know what, Sylvia, I'm really excited by this change because it's a long time coming. But what I'm also excited about is being given an opportunity together with others in our community to help shape this change, you know, to try and to drive it forward and also to introduce new initiatives, ideas that would not just help propel this change, but to ensure that it will be fit for purpose for end users in the Asian century.
That's great. Now just moving on to a couple of questions that we've received. Jeremy Pong has raised this question. Jern-Fei, you have a law background, and do you think it's an advantage or disadvantage as an arbitrator in disputes over engineering-related cases as opposed to arbitrators with other professional backgrounds, technical backgrounds like engineering?
Yes, Jeremy, thank you for your question. I'm going to give you the diplomatic answer, but it's a truthful answer, is that I don't think it's an advantage or a disadvantage. And the reason why is because one of the things why I believe arbitration is a terrific form of dispute resolution is because you can have on an arbitral tribunal a mixture of arbitrators from different backgrounds. By that, I don't just mean disciplines, i.e. someone is a lawyer by training, someone's an engineer, but even amongst lawyers, you have those who come from a common law background, those who come from a civil law background. Some will be practitioners from Asia, others will be practitioners from Europe, others will be practitioners from the Americas, for instance. And it is the diversity of an arbitral tribunal whose members have different backgrounds, different experiences that I think contribute or rather enhance the quality of the dispute resolution process. So I wouldn't want to appear before or sit, for that matter, in an arbitral tribunal where everyone is an engineer, any more than I would necessarily think that it's always a good idea to have a tribunal where all three members are lawyers. So I don't think it's an advantage or a disadvantage. I think to the extent that you have a non-law background, a non-law degree, there is a niche that you can obviously market. You can obviously use to promote your services as an arbitrator, because it means that when people are on a lookout for someone with an engineering background for an engineering related case, and you have got just that, but also you've got experience and interest in arbitration, that puts you in a great position to secure an appointment as arbitrator in those cases. And dare I say it, would actually contribute to an enhanced decision-making process, because the arbitral tribunal and indeed the parties would benefit from having that diversity of experience on the tribunal.
Great answer. Another question from Anna from Barcelona. What negotiation techniques have been more useful during an arbitration to help the parties reach an agreement? I suppose maybe as an arbitrator, you can comment on what techniques as an arbitrator have been most useful.
Yes. I'm going to make an assumption about Anna's question, because Anna's question is what negotiation techniques have been more useful during an arbitration to help the parties reach an agreement. I'll just assume for the moment, and apologies, Anna, if I've misunderstood your question, that maybe you're sort of thinking of maybe sort of an med-arb type situation, because obviously traditionally arbitrators wouldn't necessarily engage or wouldn't engage in any negotiation during the course of the arbitration. But perhaps Anna is maybe alluding to the role of counsel in the course of arbitration as opposed to arbitrator. In other words, what sort of negotiation techniques which counsel might adopt in order to help the parties reach a negotiated settlement in the course of an arbitration.
Sorry, Anna, I think we're having to interpret your question. I actually interpreted it as the techniques for the parties to come to an agreement on issues of procedure, perhaps. But
yes, I see. Yes, I think, you know what, Sylvia, let's just proceed on that basis, because that sounds like a better interpretation of Anna's question. Again, apologies to Anna. I'm sure it's our fault as opposed to we haven't really gotten the gist of your question accurately. But I think on the assumption that that is the question, certainly from counsel's perspective, or in fact from the arbitrator's perspective, I think it is important to be realistic in terms of putting forward proposals. So grandstanding is never a good idea. hewing to the extreme of a spectrum. For example, in insisting that your side gets, I don't know, sort of 90 days to perform disclosure is never a good idea. Rather, if you are pragmatic, you are realistic about it, what you do is you're more likely to strike agreement with the other side. And also you will impress the tribunal more, because the tribunal would expect ordinarily for procedural matters to be the subject of agreement between the parties. The tension, Anna, as I have often found in circumstances, especially when I'm acting as counsel, is trying to strike the right balance between doing what instinctively you know would be the right thing, and at the same time trying to keep your client happy, obviously, because there are some clients who are perhaps a bit more pugilistic than others, would want you to be a little bit more aggressive, perhaps in your dealings with your counterparts, be a bit more forceful in terms of the things that you are submitting to the tribunal on. But I think what is important is obviously to keep a steady hand on the tiller, as we say sometimes, and to educate, advise your clients that it's not always the best strategy to be aggressive, and sometimes it's important, particularly when it comes to procedural issues, simply to be reasonable. There is always going to be an element of giving and taking, and if you are trying to strike a compromise, the best way of doing so is to offer something up to the other side in the hope you can extract a concession from them on something else.
Another great answer. And, you know, another actually really great question that we've just received from Ben Cole. As an East Asian person practicing at the English bar, maybe one of the most English of English institutions, have you felt that you have been able to be your authentic self when progressing in your career?
Thank you, Ben. This is a really thought-provoking question. I have to confess that certainly in the earlier years of my practice, Ben, I felt this sort of sense of imposter syndrome because, well, it obviously started when I was even thinking of applying for pupillage, as I mentioned at the start of our conversation, Sylvia, because you can't be what you can't see, and I saw no one who looked like me, who sounded like me, with my sort of background, and so I felt a certain degree of pressure, I think, perhaps to not be myself in order to fit in once I actually managed to get in through the door. And it was very challenging. It was made even more challenging by the fact that there are people with expectations of what they expect to see when they see an English barrister. I remember vividly a client saying to me, I'm sure all subconscious, and this client was not thinking about what he was actually saying. I had a meeting with a client, and I gave him my advice on what I thought he should do. He was very happy with the advice I had given, and at the end of it, perhaps having loosened up, he said to me, he says, "You know what, Jern-Fei, that was a terrific meeting, really helpful advice. I have to say that it was not what I expected, because you were not what I was expecting when I decided to instruct an English barrister." I think he meant that as a compliment, but I think that rather exemplifies the sort of conundrum which is encapsulated in Ben's question. Over the years, as you know, and that was very early on in my career, I've now been in practice for almost 20 years. I have now come to realize that there is nothing better than to be authentic to yourself, and to be proud of it. No two counsel, no two arbitrators are the like, and you don't obviously want to simply be one of many. In other words, you are the same. You don't want to be like sort of lemmings, sort of walk in the same way, talk in the same way, say the same things, because disputes are diverse, clients are diverse. Sometimes you will want a Jern-Fei in a case, and sometimes you will want someone else to instruct in a case. Just like sometimes you will want to appoint an engineer to an arbitral tribunal, and sometimes you will appoint a lawyer to the arbitral tribunal. I am, having gotten over that sort of identity crisis in the earlier years of my practice, I have to say I am proud of who I am. I am proud that I am Chinese. I am proud that I am Malaysian. I am proud to belong to the Asian arbitration community. I'm proud that I've got a name that perhaps many people would find it very difficult to pronounce. except unless you're trying to give me a rollicking, if you're a judge or an arbitrator. But these are the things that make me special. These are the things that make each one of you special. You don't have to conform in order to succeed. And yes, life will throw you challenges. And sometimes, you will sail into the eye of the storm. I hope none of you have to face challenges as serious as some of the ones which I face. But you know what? At least the next time I see you on the street at an in-person event, and you're saying to me, I want to be an arbitration practitioner as well, I can look you in the eye and say there is no challenge you will face that I've not perhaps already faced and overcome. And the fact that I'm still standing and able to have this conversation with you and say that all will be well is, I hope, will be an inspiration that, things sometimes are not perfect. They don't always go according to plan, but you can be true to yourself and be authentic and still succeed.
Well, for my part, all I can say is the first time we met, and I don't know if you would remember this, you were unlocking the door at Essex Court Chambers next to my office in Maxwell Chambers, and you said hi to me in passing, and I instantly recognized you as a Malaysian. And therefore, from my perspective at least, that you have consistently presented your authentic Malaysian self to the world. And unfortunately, I see that we are over time now. There are still a number of questions that we haven't had the chance to address. But I think the time constraints require us to end off now. So it only leaves me to thank you once again, Jern-Fei, for your time and for all of the interesting and insightful nuggets of wisdom you have passed on to all of us. I was planning to ask you as a final question whether you had any advice that you would give to your younger self, but I feel like we might have covered that already in all of the nuggets that you shared. So thank you once again. And thank you all who are participating for your attention as well. Good night, everyone.
Thank you so much, Sylvia. Thank you, Lydia. And thank you to the HK45 community. It's been a pleasure.
Thank you.
Bye-bye.